This is what the U.S. Constitution says about religion. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof. That's it. 16 words. With so many members of the religious right arguing that America is a Christian nation, it's interesting that there is no mention anywhere in our founding document of God. Nothing about tax-exempt status. Nothing about whether or not ministers can order their congregations to vote for or against a candidate without his church becoming a political entity and thus no longer protected by this amendment. You would think that the first part, known as the Establishment Clause, is pretty self-explanatory. The state can't establish an official religion. But even that simple statement has been subject to argument between two opposing interpretations. Accommodationists think that because religion plays such a big part in their community, that certain accommodations should be made. A manger seen on the lawn of the city hall at Christmas time. The 10 Commandments posted in a courtroom. Creationism taught as scientific theory in public schools. Separationists, on the other hand, side with Thomas Jefferson, who wrote that the Establishment Clause built a wall of separation between church and state. The second part, the Free Exercise Clause, is even more problematical. The Supreme Court pretty much avoided clarifying what the limits of free exercise were for almost a century. In Reynolds versus the United States in 1879, they ruled that it did not apply to acts that were violations of social duties or subversive of good order. In that case, they ruled that a federal law outlawing polygamy was constitutional. Apparently, they saw polygamy as subversive of good order. In the 1930s, Jehovah's Witnesses held that state laws requiring them to pledge allegiance to the flag with a salute, later replaced by the hand over the heart, violated the Free Exercise Clause. In Minersville School District versus Gobitis in 1940, the court ruled against the church, saying that political authority held sway over religious liberty. A peculiar ruling, to say the least, given that even an insular reading of the amendment could hardly find such behavior subversive of good order. And the court reversed itself 3 years later in West Virginia State Board of Education versus Barnett. What about when children are involved? Recently in Texas, 400 children were taken from their families at a polygamous compound because there were indications, later found to be either false or greatly exaggerated, of abuse and forced marriages of minors. An appeals court ruled that there was insufficient evidence to hold the children and they were returned to their parents. But no higher court has ruled on the legality of removing the children in the first place. What about sects that believe that only God heals and avoid seeking medical attention for their sick children? Should the parents be held accountable? Kara Newman of Marathon County, Wisconsin, was 11 when she became ill. But her parents were members of an online church which preaches that only Jesus can heal the sick, and consequently, despite obvious indications that the child was severely ill and getting worse, never took her to a hospital. Kara died of untreated juvenile onset diabetes. The county state's attorney filed charges against the Newmans for reckless endangerment, but the Newmans argued that they should not be brought to trial because such charges were a violation of the Free Exercise Clause and therefore unconstitutional. The circuit court disagreed and ruled that the case could go forward, saying the Free Exercise Clause of the First Amendment protects religious belief, but not necessarily conduct. It seems certain that no matter what the outcome in Marathon County, this issue will not go away anytime soon. Click the link below and read about Kara and her parents. Does the judge's ruling weaken or strengthen Jefferson's Wall? Tell us what you think. CuriosityTank.com